Well, first of all, I would say that many international lawyers are actually engaged in the practice of domestic courts. So many disputes initially will be adjudicated in domestic courts. And international lawyers are involved as counsel, as attorneys. So already for finding possible solutions in domestic courts, looking at how other courts have dealt with it is very useful. Now, in terms of the international courts, I've always taken the position that decisions of domestic courts are very relevant for the interpretation and development of international law. So they're relevant for the interpretation of treaties, they're relevant as part of the practice in terms of formation of customary law, and they're relevant in terms of the subsidiary sources of international law under Article 38 of the Statute of the ICJ. So I would think that international lawyers, also for cases in international courts, would do very well, would be well advised to consider and consult cases decided by domestic courts.
Exactly, and in addition, some questions of public international law are primarily dealt with by domestic courts. You will not find many international tribunals dealing with immunity issues, although famous ICJ cases come to mind, but they are absolutely the exception. The day-to-day business of deciding whether a foreign state or a diplomat or an international organization enjoys immunity is, of course, one formed by domestic courts. And it is in that respect that domestic courts are not just interpreting treaties, of course, that's what they are. They are developing customary international law. They are contributing to the emergence of state practice coupled with opinio juris, which becomes evident in the reasoning itself. So in that sense, in a number of fields, domestic court decisions are very important pieces of the greater puzzle of public international law. And to a certain extent, of course, when we take seriously the approach, what general principles are being inspired by domestic legal systems, then we can find in the way how domestic courts apply their national law maybe something that in the end adds up to general principles of law in the sense of Article 38 of the ICJ statute. It may be a little bit difficult because this often operates on a level where we are not actually dealing with classic public international law, but maybe having resort to ordinary contract interpretation or principles of liability, which then feed into public international law general principles. But it may be difficult to really, if we would include all those cases that are relevant here, we need quite some more time.
Yes, well, I would say that there are many examples of cases where decisions of domestic court have really shaped international law. And sometimes it's a bit arbitrary to say whether it's a general principle or a rule of customary law. But if you take cases like the Pinochet decision in the House of Lords, or the Quebec decision on self-determination by the Canadian court, or the Srebrenica decision by the Dutch Supreme Court on attribution, you could construe that either as general principles or rules of customary law. But each of those cases have been cited very widely in scholarship and by other courts. And in those cases, these type of judgments definitely do have an influence on the development of international law.